Hello, everybody. How are you doing this fine Thursday? I'm doing quite well. We have two big stories going on right now. I mean, we have a million big stories going on right now, but there's two big stories I want to talk about in today's video, and that is the Diddy criminal trial and the criminal trial for Harvey Lynn Marie Weinstein. Okay, so you might know this, you might not, but Harvey Weinstein is currently serving time in prison for sexual assault of some sort. I think it was specifically R word he was convicted of back in like 2020. But then, I don't know if you knew this or not, April last year, almost exactly 1 year ago, Harvey Weinstein's conviction was completely overturned. It was thrown out. It was garbaged up into a ball and thrown into the trash can. The judge said absolutely not. Well, the judge did permit for there to be a retrial. He said that was really the only fair thing to do, was to do a retrial. So the retrial is starting like pretty much now. Harvey Weinstein today, April 10th, is going to be in court. He was also in court yesterday shouting out Candace Owens and Joe Rogan. So it's really heating up. Now, on top of just sort of the obvious kind of common sense, intuitive similarities that these cases do bring to mind, moguls in the entertainment industry being accused of similar things, not exactly the same thing, okay, but being accused of similar indiscretions, both being tried criminally, and both of them ran in similar circles. I mean, there's pictures all over the place of Jay-Z with Harvey Weinstein. The Weinstein Company was the one who bought the rights to Erica Kennedy's book, Bling. I mean, I could go on and on and on. Those are just the first two that came to my mind. But a lot of people have drawn similarities between Harvey Weinstein, Jeffrey Epstein, and P. Diddy. A lot of people have drawn these similarities. There are some similarities to draw, like the locus of a lot of the stuff was like New York and Miami or whatever. Well, not only those common sense similarities, but now Diddy has, as of about 2 days ago, filed oppositions in his case that actually cite the Harvey Weinstein overturn ruling. Okay. So I've been trying to figure out how to present this information to y'all because it is complex, it's complicated, and it's kind of like nuanced and in the weeds. But I'm going to try to present it to you in a way that just kind of like we get to the high points and we get to the like TLDR. I do have my handwritten notes that I think may be helpful for some of y'all to understand what's going on, but I'm also going to pull up the actual rulings. I want to make a disclaimer verbally. There's one in the scrolling bar down below. I probably will have to make the disclaimer many times. These notes are just notes. They're not supposed to be facts. They're not supposed to be the end all be all. And I'm not even saying that they're all necessarily correct. This is just notes that I wrote for my personal notes, for my personal notebook. And I think maybe, now that they're written, it might be helpful for y'all, but they're not necessary to understand what's going on. And I do want to just, again, make the disclaimer. These are not facts. Okay. This is just notes that I wrote trying to understand what's going on. Okay. So let me pull those up. Okay. What do I have here? Harvey Weinstein 2020 conviction overturned. Okay. As you can see, this was 2 days ago that I put the little date up there. Similarity to Diddy, I'm wondering, because the last thing I want is Diddy to get convicted of something and then get let out forever. Then I put Diddy cites the Weinstein ruling in the motion to exclude and his memo. Okay, so what happened in that Harvey Weinstein case was that three women, that this is at issue. A lot happened in the case, but this is what's at issue. Three women provided testimony of, quote, prior uncharged acts. Okay. So they went in and they talked about incidents that occurred with Harvey Weinstein. Now, importantly, very importantly, because this is going to map onto the Diddy case, the alleged victims who came in and gave this prior uncharged acts testimony, the reason it's called uncharged acts is because nobody ever got charged on the acts. So essentially, and I will tell y'all, Candace Owens has a whole entire series on this where she really gets into a little bit more of the details, the specifics of this. But the purpose of this video is not just to reiterate what she has said. Okay, the purpose of this video is to take what happened in Harvey's case, apply it to Diddy's, and tell y'all how, if the judge isn't careful and if these prosecutors aren't careful, that Diddy could also have his ruling overturned just the same way that Harvey Weinstein did. And in fact, and indeed, by the end of this video, I hope that I'm able to relay to y'all my belief. I'll show you the evidence for my belief by the end of this that Diddy actually would have a stronger case to have his case overturned than even Harvey did. But Harvey's already got overturned. So what does that tell you? It tells me the prosecutors are heading down a dangerous, slippery slope, in my opinion. By the end of this video, you can let me know if you agree or not. Okay, so these prior uncharged acts, there were these 3 witnesses that were not actually listed as victims. These were just women from the past, just women from the past. Now, there's 2 options about these women's testimony. Either one was it's true. It was true. What they said was absolutely true. And then the other option is they were lying. Now, I'm not going to get into whether or not I believe or whether or not they were shown to be lying or telling the truth, because in this case, it actually did not matter. And referencing back to these notes again, these 3 women who did give the testimony on unrelated charges, which were not charged prior acts, that was the reason, one of the 2 reasons that Harvey Weinstein's case was overturned. Now, we will look at that decision, that opinion, in just a moment from the appeals court, but let's finish this page of notes. So there's an issue up for dispute in the Diddy case right now. Filings were just filed. Actually, any arguments against him, I think, are due today. It's hard to keep up with the timelines, but just 2 days ago, Diddy and his lawyers filed a motion in limine to exclude certain testimony. The testimony that Diddy wants excluded is specifically, precisely, exactly the same type of testimony that got the Harvey Weinstein case overturned. Let me show you what I mean. What we're looking at here is docket 213 filed on the 7th. Excuse me, I might have said earlier it was filed on the 8th of April, but it was actually filed on the 7th. This is Diddy's motion to exclude certain evidence. Okay, so just remember, this is very important. The so-called certain evidence that Diddy wants excluded, we're about to be talking about rules. We're going to be talking about 403, 404, 413. We're going to be talking about all these numbers going to be flying around, but I just want you to remember for clarity. I just want you to remember the evidence at issue, the whole thing Diddy is trying to keep out is specifically testimony. Okay. So the government, the feds in Diddy's case, have said, we intend to call individuals 1 through 4 to the stand. Okay. Maybe they call them non-statutory victims. I mean, they're always doing this wordplay stuff, but essentially these are not victims of charges that Diddy is facing charges for. And these are not victims of alleged charges that Diddy has ever stood trial for. He's never been convicted of this stuff, and he's never even been charged. He's never even been charged with this stuff. Okay. So these are going to be people who are going to come in if the government gets their way, the feds get their way. They would come in and say, oh yeah, for example, I hooked up with Diddy in 1992, and when I did, he XYZ. And then Mark Agnifilo, Diddy's lawyer, whoever, one of his lawyers would come up and say, did you say no? Did you blah, blah, blah? Did you report it to the police? And then the person would answer the question, either yes or no. But the answer we already know. We don't know who these people are. I think it's 4 individuals who have all had prior relations with Diddy, allegedly. They claim, but these allegations they're going to be making are just their own personal memories and experiences. They could be telling the truth. Even. I'm not even saying, oh, they're going to get up there and lie. They could get up there and tell the truth. So the evidence, just to simplify it, the evidence that Diddy wants to exclude is specifically the testimony. He does not want them to come up there and sit on the stand and talk about prior things that happened. Now, Diddy has a lot of strong arguments. Some arguments are not strong at all, but some of them are extremely strong. Like, for example, relying on the Harvey Weinstein case. The case has already been overturned, y'all. This isn't something that's theoretical, okay? It already happened. Harvey Weinstein is going back on trial next week because it got overturned the first time. Raise your hand in the chat if you're excited. We have to go through the Harvey Weinstein trial all over again. Raise your hand if you think the victims, alleged so-called victims. Raise your hand if you think maybe there's going to be a little bit of problems now with making sure Harvey Weinstein gets a fair trial. One way or the other. He may be able to eventually bring up that he's already been acquitted once on this and this is a witch hunt or whatever. All strong arguments that could have been avoided had they taken this argument seriously. So here I am pointing to the canary in the coal mine. Spent the last 2-3 days trying to figure out how to best deliver this information to y'all, because what the last thing that I want is for y'all to misunderstand me. I spend a lot of time trying to put these videos together, even though I don't work for y'all, trying to put these videos together because I think it's important to make sure the public actually knows what's going on actually in the court documents, not just what the media matters, what the AstroTurf campaigns on anybody's collective, reflective, respective side is saying, okay, what's actually going on. And so the last thing I want is for people to come to this channel and think that this is like, I got a shill for somebody over here channel, or that I'm trying to take up for the behaviors and the actions of the likes of anybody. So I just want to tell y'all what happened, because the last thing I want is 2 years from now, 4 years from now, we're looking at the same exact situation done happened again whenever it could have been avoided. I strongly believe everyone, including Diddy, including Harvey, including anybody, has a fair trial. Not only because it's the right thing to do in the interest of justice, not only because it honors the ultimate truth, but also because sometimes bad people get convicted because they didn't have a fair trial whenever they could have had a fair trial, still got convicted, and now it's overturned. You know, sometimes it's that, okay? So don't take me talking about this stuff as if I'm trying to give Diddy a pass or I think that he's innocent of things he's being accused of. But I'm also not going to I refuse to be one of these YouTube channels that is 100% hardcore no matter what, despite logic, despite reason, despite fairness or justice, and despite the truth, out here just shilling against Diddy. I'm just not. There's a lot of channels out there y'all can go watch, but this ain't the one. Okay, so Diddy filed just 3 days ago this 39-page document trying to exclude the testimony of these individuals who claim that they have had previous relations with Diddy, and they're going to come sit on the stand and talk about their relations. Now, Diddy has a lot of reasons for not allowing this testimony in, and to be honest, they're very strong. If I was the judge and I was reading all these papers, I won't bury the lead, it would be very difficult for me to allow these victims, these alleged victims, to sit up on the stand. And the main reason for me, this part's my opinion, is because Diddy is not accused of SA specifically. He is not accused of SA specifically. He is accused of ST. Now, a lot of people are going to say that's the same thing. And to those people, I would say, no, it's not. In the law, if something is duplicative, aka the same thing, there would be no legal distinction between the statutes, and there would be no legal distinction between the definition. But in fact and indeed, ST has had a very specific designation and definition, which is specifically distinct from SA. SA is alleged in some ways in the indictment, but you know what's not alleged in the indictment? Any statute, okay? Now, Harvey Weinstein, he was accused of SA. He was. This is going to become important because we're going to talk about some rules. And I told y'all it's taken me a couple days to even organize my thoughts on how I even wanted to present this information to y'all. This is going to probably be a long video, so buckle in. I thought about ways to make it shorter, and I don't think it would do it justice. So we're just going to be here for a while today, okay? So just buckle up. But I do think once we're done here, and I would appreciate if y'all did stick around because I put a lot of work into this, I really want to relay to you the underlying specific issues going on. And there's no way to do that unless we just go through it and it's just, we get through it together. So let's get through the drama together. Also, this video is brought to you, sponsored by me and my new merch. This video is brought to you by my new merch. Get it right now. Get it as soon as you can because it's probably going to be sold out. We have the tote bag. We have a tote bag for the first time. Get your tote bag at ThatSurpriseWitness.com. So instead of reading through verbatim 40 pages, I'm just going to show y'all the table of contents. We'll start there, okay? The proffered evidence. What's the proffered evidence? It's the evidence the government wants to submit, aka the testimony of people who are not victims pursuant to this case, right? There's victim 1, victim 2, victim 3, and victim 4. Those are the people who had incidents, experiences with Diddy that the government's actually charging Diddy for. Victim 1, victim 2, victim 3, victim 4. But there's these other people. There's other people they want to bring in to testify about other stuff, other different stuff, not victim 1, 2, 3, and 4. Other people, other victims from 1989 or something. Okay. So there's two different separate victim, quote, victim categories. All right. Rule 413 is where Diddy starts. Okay. So what are these rules? You might be wondering. Well, there are rules of evidence. We're going to get to them in just a moment. Rule 413 in and of itself is an exception. Rule 413 allows certain evidence in that would not be allowed in otherwise, okay? We're going to talk about it more, but this is just the 50,000-foot overview. It might feel confusing. It might feel like I'm repeating myself a lot, but by the time this video ends, I promise you're going to feel like you learned something. Now, not only is it not admissible under 413, it's also not admissible under another rule of federal evidence called Rule 404. 404B is the specific one they list, but they also seem to be relying on 404A. We will talk about that in a moment. And then separately and apart, there's a whole nother rule that Diddy is arguing precludes or makes it to where this evidence cannot come in. So independently on their own grounds, each and every one of these reasonings that Diddy provides would be enough to not allow the evidence to come in. Okay. If he could prove it, Okay. And then he says, at the very least, I need a preliminary hearing. We need a hearing, a little miniature hearing on this specifically, on this matter, so that we can make our arguments. So in this filing, he does rely on the Weinstein overturning. Okay, look, table of authorities, page 16 and 17, he mentions Weinstein. Look, reversing admission under the People v. Weinstein, describing significant differences between complainants and the Molyneux witnesses, including all three complainants had long-term relationships. Okay, so Diddy is trying to say that his case is similar to Weinstein. I want to pull up this note again because this, I feel like, is just an easier, simpler way of describing it. Again, this is just for understanding purposes, comprehension purposes. They're not supposed to be a fact. So the overarching issue, should the judge allow the witness testimony to come in from the prior uncharged acts against Diddy? That's the question. That's the issue. Should the judge allow these victims to testify, these alleged victims to testify? Because I have to say alleged. Do you want to know why? Because Diddy has not been convicted. He has not been found liable, and he has not even been charged ever on these issues. Okay, so I have to say alleged. I'm not even talking about like Cassie and the other victim. No, these are different people. So the question is, does the judge allow that to come in? Yes or no? Diddy says no. Why? Rule 413 doesn't allow it. Rule 404B doesn't allow it. Rule 403 doesn't allow it. So what does that mean? What are these rules? Well, let's read further on my little notes. So there's rules of evidence, okay? They're based off of ultimately this sort of elusive principle of fairness, justice, what's right, accountability. That's what they're supposed to be based on. Fairness, fair trial, stuff like that. Not only are they based on those things, there are other foundational principles which are enshrined in the Constitution, like, for example, the presumption of innocence until you're actually proven guilty. And this is different than like the French Napoleonic Code, for example. Defendants are not always assumed and presumed innocent until proven guilty. This is kind of a unique presumption of American jurisprudence, okay? But the rules of evidence themselves have rules on top of them, okay? They have to follow certain rules. You can't just write a rule that lets you do anything. It has to follow all the case law. It has to fit into the precedent. These rules of evidence cannot violate the United States Constitution. Nothing can violate the United States Constitution. I mean, they do. They get violated all the time. But we're talking about theoretical foundation, right? We're talking about fundamental framework underlying the system. It's supposed to be constitutional supremacy, meaning the Constitution is the law of the land. You want to change the Constitution, you better put in an amendment, and there's rules to do that. So these rules of evidence are constantly kind of being checked being run through different types of scenarios in order to make sure that they're still following the rules they were supposed to follow. So the step one, the first thing you got to do with every single piece of evidence that comes through a trial, especially a criminal trial, has to run through the federal criminal rules of evidence. So number one, you got to run it through the test for relevance. If evidence is irrelevant, there's no reason to bring it. For example, let's say Diddy wanted to introduce that evidence, a pretty picture that he painted in jail. But that's it. Oh, I just want the jury to see my pretty picture. Well, what does that have to do with anything? That's completely irrelevant. Get that out of here. Okay. So first question of all is it relevant? But that's not just like, oh, gut check, is it relevant? No, 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 no. This is the legal capital R relevant. And so what does that mean? What do you have to ask as a court, as a judge, as both sides? The question for relevance ends up being twofold. Number one, first question, before you can put evidence in at all, we are not even talking about Diddy's defenses. We're just talking about the rules of evidence only. Number one, does the evidence have the tendency to make a fact more or less probable than it would be without the evidence? But not just any fact, like that Diddy painting a picture in jail, for example. That might be able to prove some fact, like that Diddy painted a picture in his life, or that he did something in jail, or whatever, right? There's a fact that could be proven with the pretty picture he painted in jail. Maybe that he still has the ability to make art, whatever. But that's when we arrive at point B. The fact that the evidence has the ability to not prove that it definitely happened, but to make more or less probable. Doesn't make it more likely, more probable. The fact must be, quote, of consequence in determining the action. Okay. So first of all, is it even relevant? Diddy's lawyers argue it's irrelevant. Diddy is not charged with SA. He's charged with ST. A lot of y'all are going to say it's the same thing. You can have your personal feelings and your personal opinions about whether something's fair, right, just, or relevant. And then there's just like the way it actually has worked. There's the way that it will work. There's the foundations. You can just overcome them. So we will discuss this more in the Rule 403 argument, which we will get into now. 403 is one of the arguments Diddy relies on in saying that this witness testimony should not be allowed. Rule 403, the court, even if evidence is relevant, can exclude this relevant evidence if the probative value, what's the probative value is this right here, the tendency to make more or less probable, whatever, whatever. If the probative value is, quote, substantially outweighed by a danger of one or more of the following. So all Diddy has to prove is one. Okay, that's one thing I want to show y'all in the next picture I pull up. There's like a lot of theories upon which Diddy might be able to get this stuff excluded. And if he could even do one, if he could prove the court one, then the whole thing gets excluded. Okay, this is not a cumulative. It's not cumulative. He doesn't have to prove it all. Actually, under Rule 403 alone, Diddy has several arguments. Now, some of them are stronger, some of them are weaker, but he has several arguments to show, look, Your Honor, even if this witness testimony was fair and somehow allowed in, it still has to be kept out because any value of this is substantially outweighed by a danger of unfair prejudice and by a danger of the jury confusing the issues. So let me pull up the next page of my notes and I'll show you how he lays that argument out. Again, this is just my notes that I wrote 2 days ago, just trying to kind of understand the case a little better myself. But we're going to start on the top half of the page. So don't worry about the Rule 404B. Right now, we're just looking up here. We're still working on the 403. It's when we just started. So see my note up here? Diddy has pled 5 separate independent grounds on 403 alone. So without even getting to 404B or 413, he's got 1, 2, 3, 4, 5 different reasons why he thinks that this doesn't pass the 403 test. So what's the 403 test? It is the test that says, is the probative value of this evidence less valuable than the harm, right? You're putting it on the sides of the scale. I need to get my little scale back from over there. I have one downstairs. Let me get it. So on one side of the scale, there's some value, there's some relevance. On the other side of scale, Diddy's saying there's 5 things. Number one, he says the probative value, any value that this might have, this testimony might have, is, quote, substantially outweighed by all of the following. Number one, it would be unfair. It would be unfair prejudice because Diddy has been preparing this whole entire time on a coercion theory, ST, RICO, racketeering, whatever. And Mark Agnifilo is saying these people, these feds have known about these victims, have known about these allegations for a long time. But even as of right now, today, even today, sitting here right now, Thursday, April 10th, even Diddy does not know the names of these people. Mark Agnifilo is saying, this is crazy. We should have been able to be looking into these people. We should have been able to be working on this. And even still now, we can't even. This is so unfair. So that's one argument. The fact that the government now wants to rely on this late in the game, that's another argument Diddy makes for it being unfair. Now, you can decide on your own whether you buy these arguments, whether you care and all of that. I mean, I'm not trying to tell you what to think about that. I'm just telling you the arguments he's making. Diddy also argues, his lawyers do, that there's danger that's just inescapable of confusing the jury. So if you allow these people to come sit on the stand and talk about coercion, talk about force, talk about SAs, all that, like leaving literally all the other problems with that aside, just only itself, the jury is not going to understand what they're even supposed to be looking at. Because on the one hand, you have these victims. On the other hand, you have these other victims. You're not charging them for any of the stuff that you have those first victims on the stand for. So it might confuse a jury as to say, why are these people here? It must be important. Now, the feds, to give you their side of the argument, they argue that the judge can fix any possible confusion by just instructing the jury and saying to the jury, remember, he's not on trial for SA. He's not on trial for any of the things that those other alleged victims said. That's what the feds say. The judge can just fix it. The judge can mitigate any potential confusing of the issues by giving a curative instruction. But Mark Agnifilo responded back and said, no, they cannot. No, the judge cannot. This would be difficult for even a lawyer or a judge to keep separate. It's too prejudicial. It substantially outweighs anything that could possibly help to prove. What could it even possibly be there to prove? If the government wants to charge him with SA, then they need to do that, essentially. I mean, he didn't say that. But also the same issue on misleading the jury. So confusing the issues, ST, SA, misleading the jury. What are they even supposed to be looking at? What are they supposed to be considering? And then Mark Agnifilo argues that there's two other reasons under Rule 403 alone. If even one of these is proven to be more harmful than the probative value, then Diddy can have it excluded. So the other two reasons under 403 alone that Agnifilo and Diddy and them argue is undue delay and wasting time. And I already did mention this a little bit earlier, but this undue delay and wasting time is Mark Agnifilo is saying, and this is how it kind of starts to reckon back to the Harvey Weinstein case. Mark Agnifilo is saying, not only did the government have all this time, all these months to tell us that this was going to be their argument, but also these are uncharged, unproven allegations. Diddy's lawyer is saying, which it is true. They are uncharged. That's true. Diddy's lawyer is saying, we are going to have a whole bunch, a series, he says, of, quote, mini trials, miniature trials. We're going to have a whole bunch of miniature trials before we ever even get to this on whether or not these women are telling the truth. We don't know what these people are talking about. Also, a lot of this stuff that they're talking about was from 30 years ago, 1980s, 40 some, maybe close to 40 years ago. It's just been way too long. And we're going to have to do these little miniature trials even to elucidate whether or not, to determine whether or not these stories are even credible, whether this stuff happened. This is just going to waste a lot of time, which starts to interfere with some of those fundamental principles that we talked about earlier, like the right to a speedy trial. Diddy is arguing, I don't even know who these people are. I don't even know their names. And some of you might not be sympathetic to Diddy. Fair. But what if it was you? They don't even want us, the public, to ever know who these people are. They don't want the public to ever know who these people are, but they're planning on using these people to lock somebody away forever. How are we going to check if that was fair? If they can do it to Diddy, they can do it to the next person. And then finally, there's also the argument Diddy makes about the fact that they could have brought this up already, but they just didn't. So too late. Now, this is discretionary. The judge himself will be able to make this call. Judge Subramanian, the 403 test, also had the balance of the probative value balanced with any harm it might cause, but the judge does have to apply the specific facts of each case. And I even put a quote here from the Weinstein case, and it says, quote, "It is the solemn duty of the court to diligently guard and protect fundamental rights." Okay, so the judge has significant discretion in this particular evidentiary rule, the 403 rule, and he can and he will consider any possible factors within this analysis. Okay, so Diddy argues Rule 403, but he also argues Rule 404. Specifically, they cite Rule 404B, but what is Rule 404? Well, this is the rule that has to do with so-called character evidence. Rule 404A and B combined together also talk about other crimes that someone may have committed and prior bad acts they may have committed, even if it wasn't a crime. Now, there is a very long and very strong history in the United States American legal system with keeping this type of evidence out. You're going to see this type of evidence excluded. It does make logical sense if you think about it, but the emotional kickback is probably your first response. No, why? If he committed a crime before, it should be fair game. I know y'all like to say fair game. I understand that's your feelings. However, let's look at the facts. Let's look at the facts. Is it actually the case that just because somebody did something yesterday, they necessarily did it today? For example, I ate a bagel yesterday. Did I eat a bagel today? No, it's not factually certainly the case that just because someone did do a crime in the past, that they're going to do the same crime or that they did do that same crime on a specific date. Also, there is a sort of cumulative danger that comes into place where maybe the crime has nothing to do, maybe the prior crime has nothing to do with what you're on trial for today, but the jury might just think you are a piece of beep and want to just put you in jail anyway because you're going to commit a crime anyway one day, so just block you away now. None of these things are fair and none of these things are logical. Some of y'all might be saying, well, who cares about fair? Because Diddy shouldn't have did what he did. Maybe he shouldn't have. Maybe he should have. I don't know. Innocent until proven guilty. But how about the government should charge people and convict people on the stuff they really did? If Diddy really committed crimes, then the government should be able to show proof that he did. It shouldn't have to come down to all of this piecing everything together up, down, around the corner and around the mulberry bush to try and figure out, like, can you get us something a little more straightforward? They worked on this for years, this fact finding. And anyway. Rule 404B, but also A, they are trying to use as well. So remember, it might be the case this 404 argument doesn't even need to come in because 403, one of those 5 things already just said, no, we got to keep the testimony out. It's just not fair. But let's say they're not convincing on that one. Let's say the judge gets to the 404B argument. This is the prior bad acts and the character evidence. So the rule here is evidence of a person's character is not admissible. So Diddy is a bad person evidence. Diddy is a a-hole. That type of evidence is not admissible if the purpose that it's being presented is to show or to prove that a person, Diddy in this case, acted in accordance with that particular trait in a particular instance. So Agnifilo is saying the only reason they're putting this in here is to say that Diddy is a sexual deviant. And even if he is deviant, this federal case is very misleading. It's sneaky because they do put deviant allegations within the complaint, but he isn't being charged. He isn't being charged for forcibly putting his body on somebody else. He's being charged under more of this sort of lover boy theory of coercion. They probably should charge him with that, and I'm curious as to why they don't, but they don't. They don't. So Diddy is arguing, and I do think he makes a strong argument, but I mean, I would be open to, debate or whatever. Diddy argues the only reason they're trying to put this testimony of these prior uncharged acts in here is to prove that I have a certain character. And then they're going to they're going to try and tell the jury, look how messed up, look how effed up this man is. Don't you think it's obvious that he also was messed up in this other scenario? which again brings back in 403, which is kind of like confusing the issues. What is the issue really? Is it ST, RICO, racketeering? Or is it SA? And if it's SA, why isn't he charged with that? Now, there is a special rule in criminal cases for Rule 404B, which is that then there is a notice requirement. Diddy and his lawyers were required to get reasonable notice of the evidence that the government wanted to present, and it needed to have a fair opportunity to meet the evidence, to research, to look into it, background, all that. Not only is that required for criminal cases, which Diddy's is a criminal case, B, it has to articulate, the government has to articulate in the notice what the purpose is for them offering the evidence, and they have to give the reasoning that supports the purpose. So they have to kind of brief it out. They have to convince the judge, look, here's the notice within the notice. I'm telling him exactly what he can expect, and has to be in writing before trial. Well, Diddy's arguing the government has violated both requirement A and B. These would be, according to Diddy's arguments, two more independent grounds. Why? Because the government is required to do them, and they did not. And so since they did not, they do not get to use that rule to bring evidence in. Diddy says the feds violated the notice requirement because still to this day, right this very second, right now, they haven't told Diddy who these people are. He doesn't know who is going to be testifying against him, and his trial is in a month. Number two, Diddy argues that the feds violated the notice requirement also because it isn't specific. Like, they're not really saying why they need this testimony. They're supposed to be able to say, we are putting this evidence in here for the purpose of fill in the blank. And the blank cannot say to show that he's depraved, to show he has a bad character. It's just against the rules. It just is. I understand people have problems with it, but it's just the rule. It just is. You cannot bring in propensity evidence. Oh, he has a propensity. No, you have to show that he did in fact, or it has to be a victim that's like actually it's a victim of something that he's being charged with. Now, I do want to very briefly discuss Rule 413 because that is the final argument that Diddy is relying on in order to get this testimony excluded. This is the similar crimes exception. So remember earlier, just moments ago, whenever I said, I know you may have a problem with Rule 403, but it just is the rule. Well, y'all aren't the only one who had a problem with it because some other people had a problem with it too. And that's why Rule 413 exists. Rule 413 applies where in a criminal case, if a defendant is accused, quote, accused of an SA, the court can admit the evidence. So the court could let it in, which would mean Diddy would lose on this argument. But the only way they can let it in is if they can show that Diddy committed any other S assault. Okay, so as you can see, I've written exclude here in red. These are Diddy's arguments. So 4 separate reasons in this rule alone that he's saying this rule does not allow them to put this evidence in. This is supposed to be an exception that is supposed to allow certain evidence in. Sure, Diddy agrees, whatever. But because Diddy is saying he is not accused, charged with an SA. Well, the feds are arguing he did S assault. He did. S is S assault. But Diddy's argument, and I think it is convincing and compelling, is that he isn't charged with S assault. And I think it's convincing and compelling because look, I said it in the pink right there. Why didn't they just charge him with one? Because in the Harvey Weinstein case, he is charged with S assault and they let this type of evidence in and it still got overturned. Diddy's not even charged with an SA. So this could be a possible other grounds, a whole nother grounds that Diddy's could be overturned that Harvey didn't even have. And remember, Harvey's was overturned. So let me pull Harvey's opinion up. Okay, this is from last year, and this is what the judge said. So you don't have to take my word for it. You can look at what the judge said. Look at the first sentence. The first sentence. Quote, every person accused of a crime is constitutionally presumed innocent and entitled to a fair trial and the opportunity to present a defense. It's a fundamental liberty secured by the 14th Amendment. The presumption of innocence is a basic component of a fair trial under our criminal justice system. Whether it's rooted directly in the due process clause of the 14th Amendment or the compulsory process or the confrontation clauses of the Sixth Amendment, the Constitution guarantees criminal defendants a meaningful opportunity to present a complete defense. The Weinstein judge goes on. Under our system of justice, the accused has a right to be held to account only for the crime charged, and thus allegations of prior bad acts may not be admitted against them for the sole purpose of establishing their propensity for criminality. Okay? Under our system of justice, a defendant has the right to be held to account only for the crimes charged. Now, is Diddy charged with SA? This is a whole separate question that's going to come up that Weinstein didn't even get. Okay. So Diddy could have his case overturned if the feds want to put this in. But Diddy also has another protection, and that is that there's a strong argument he's not charged with S assault. Under the law, ST and S assault are not the same thing. They're just not. In your feelings, they might be, but they are not the same. There would not have two separate statutes. Battery and assault would not have two separate statutes if they were the same thing. Theft and fraud would not have two separate statutes if they were the same thing. Are they both crimes of being dishonest? Are they? Yeah, sure. But fraud and theft are not the same. Robbery and burglary are not the same. In the same vein, Rule 413 says you can admit evidence that someone SA'd somebody in the past if they're being charged today with SA, but Diddy is not. I really want to make sure, put a 3 in the chat if you really get it now, because I don't know, I just feel like I need to keep reiterating. Harvey Weinstein's case is pretty similar to Diddy's as far as what the arguments are for keeping this testimony out, but Harvey Weinstein was actually charged with SA, and Diddy was not. Under our system of justice, the accused has a right to be held to account only for the crime charged, and thus allegations of prior bad acts cannot be admitted against them if the sole purpose is to establish the criminal propensity. Okay, the propensity to do a certain action. Quote, nor may the prosecutors use, quote, prior convictions or proof of the prior commission of the specific criminal, vicious, or immoral acts other than to impeach the accused credibility. It is our solemn duty, the judge says in the Weinstein case. This is just 1 year ago, not even a full year ago, this decision came down. It is our solemn duty to diligently guard these rights, regardless of the crime charged, the reputation of the accused, or the pressure to convict. That's powerful. And it's the judge saying, y'all, stop bullying the courts. If you want to do it out there in public, do it over there. But if you're coming into the court, this is what you should expect. It is our solemn duty to diligently guard these rights he just laid out. You have the right only to be held to account for the stuff you're actually charged with, the stuff you've actually been convicted of. And the only time you can actually even bring in convictions is very limited. It is our solemn duty to diligently guard these rights, regardless of what crime is charged, regardless of if they have a bad reputation, and regardless of the public giving pressure on the courts to convict somebody. It is the duty of the courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachments thereon. Defendant, this is Harvey Weinstein, was convicted by a jury for various SUL crimes against 3 named complainants. And on appeal, he claims he was judged not on the conduct for which he was indicted, but on irrelevant, prejudicial, and untested allegations of prior bad acts. What did the judge say in this case? We conclude the trial court erroneously admitted testimony of uncharged, alleged prior SUL acts against persons other than the complainants. So this isn't victim 1, 2, 3, and 4. In Diddy's case, this is non-statutory victims. The testimony served no material purpose other than propensity. Okay. So here is a judge. There's a whole retrial. Harvey Weinstein, #MeToo, the face of #MeToo. Okay. He's got his conviction overturned. Why? Because they let in testimony of prior allegations, not even prior acts. It wasn't even like a video of it. It was testimony. It was somebody just saying it happened. The judge overturned the Harvey Weinstein ruling on another ground as well. The trial court, he's kind of like admonishing the lower courts now for being stupid. The lower court compounded the error when it ruled that Harvey, who had no criminal history, so they couldn't bring up prior convictions because he had no criminal history, could be cross-examined about those allegations, as well as numerous allegations of misconduct that portrayed him in a highly prejudicial light. Okay, so the court is saying not only do I have to overturn it because the trial court really violated Harvey's rights, violated the rules of evidence by allowing testimony in of prior acts that there really was no charge for, there was no conviction for. In fact, he had no criminal history. They just let these people come in and testify to things. That's reason number one, it got overturned. But reason number two, it got overturned is because the court effed it up even further. Again, this is not my opinion. This is me reading from an order. The court effed it up even further, and even further, it needed to be overturned whenever it ruled that Harvey, who had no criminal history, could be cross-examined. So not only could these people just get up there and who knows, maybe they're lying, maybe they're telling the truth. That is the whole point, though, is that we don't know. And then allowed Harvey to be sat up on the stand and asked questions about it. Now, Harvey did not do that. He declined to testify in his own defense, specifically in part because of this. Like, imagine you're on trial. Some people that you maybe did something with 40 years ago, 35 years ago, shows up telling their recollection of it. Maybe their recollection in their mind and their heart is true. Maybe that's not what happened, though. Maybe it is what happened, though. But for 35 years, you haven't been convicted. For 35 years, you haven't been charged. And now, all of a sudden, not only does that person get to come and sit and tell the jury about all the horrible things you did without ever having to have actually made that claim to a police officer, to a judicial officer. Now imagine it's 4 or 5 of them. And in order for you to defend yourself, you also have to answer questions about that. Like, it is really, truly, I do agree with Mark Agnifilo. It is a miniature trial you have to have. It's a miniature trial. These are separate charges, separate acts, and separate incidents. But we're talking about testimony, and specifically that is what got Harvey Weinstein's case overturned. Ruling, conviction overturned. The synergistic effect, the judge said, of these two errors was not harmless. The only evidence against Harvey was complainant's testimony. And the result of the court's ruling was to bolster these people's credibility and to diminish Weinstein's character before the jury, which evidence can do that. Evidence is allowed to diminish someone's character. There has to be some purpose that outweighs the harm. Number 403, we had the two sides of the scale. There is going to be harm that comes to people when you present some evidence. Some evidence is going to be harmful. The CNN tape, for example, I mean, that's another one that they are arguing over, but the CNN tape is harmful to Diddy's character, but maybe there's other reasons to include it or not. So it isn't that it's just harmful in and of itself. It was so harmful because there was nothing balancing it out on the other side. The only evidence against him, and look what he calls it, an untested allegation. Untested. It never stood the test in trial. The only evidence against him was the complainant's testimony, and the result of the court's ruling to let their testimony come in. The trial court allowing this testimony to come in at all biased Harvey so much that the only remedy is a new trial. The judge says, on the other hand, the threat of a cross-examination highlighting these untested allegations, quote, undermined Harvey's right to testify. So he wanted to testify in his own defense, and you do have a right to do that. You also have a right not to. Under the Fifth Amendment, you can remain silent. You don't have to. You cannot be compelled to testify in your own defense in a criminal case. But the judge is saying the fact that the lower courts were going to allow questions on these untested, uncharged allegations of prior bad acts, as if they were fact, as if they had certainly been established when they had not, because they were, quote, untested, that also prejudiced Harvey. Now, as far as the cross-examination issue, that has not been reached in Diddy's trial. So the second prong, the second reason that Harvey Weinstein's case was overturned, that has not yet come up at issue in Diddy's trial. It could or it might not. The judge says in the Harvey opinion, the remedy for these egregious errors is a new trial. And then Harvey had made some other argument about a certain charge being untimely. The judge dismissed it. That didn't end up being one of the grounds or one of the reasons upon which the judge based the overturning. So that's what that paragraph is. Defendant Harvey Weinstein was charged with 1 count of first-degree criminal S act under the penal law based on allegations that in 2006 he forcibly did something to a complainant. He was also charged with 1 count of first-degree R and 1 count of third-degree are based on allegations, testimony. This is what they want to let in for Diddy. That on March 18th, 2013, defendant engaged in forcible bleep and bleep with complainant B. The court denied his motion to dismiss, and then it says he was tried before a single jury on all counts. He was a powerful, well-known man within the industry, produced several films. The prosecution's theory of the case was that the defendant abused his power to take advantage of aspiring female actors, like complainants, to coerce them into unwanted sexual encounters. According to the prosecution, the quid pro quo of assisting them with their careers in exchange for sexual favors was common behavior and a well-known secret throughout the film industry. What is a well-known secret? When his victims resisted, the prosecution argued defendant would use force. Traumatized by his SAs and fearing retaliation, the complainants never reported the attacks and continued personal and professional relationships with him for years. Before trial, the court had granted the prosecution's application to admit certain testimony of what? Uncharged crimes and miscellaneous bad acts. As an exception, remember, exception 413, to the Molyneux rule, prohibiting such evidence. So there's a rule that prohibits this type of character evidence and the prior bad acts. But the purpose, remember, the thing that's important is the purpose. Why? Why? Is the only reason just to show that he's a deviant? Well, the prosecution said no in Harvey's case. The prosecution said, no. The reason was to establish Harvey's intent and his understanding that the complainants, the victims, they didn't consent. So it wasn't to just make him look like a creep. No, Your Honor, the prosecutors said. Sorry, if I've been calling these people feds, my bad. This is a state case. This is not an SDNY case. I do get confused from time to time. And feds is just like a shorthand, but I'm talking about the state, the prosecutor, the government, whoever it was in this case. They said, no, Your Honor. We're not trying to submit this testimony to show that he's a depraved freak. No, it's to establish his mental state, the mens rea, the intent, and his understanding that the complainants did not consent. So complainant B could testify about defendant's uncharged sexual assaults against her before and after the actual charged R. She could also talk about her awareness of Harvey's abusive and threatening behavior, and 3 other women could testify regarding defendant's sexual misconduct toward them before and after the charged offenses. Okay, the court also granted the thing where he had to testify against himself. So then the judge just kind of lays out some of the factual allegations from complainant A. Complainant B testified she wanted to act since she was a kid, first met Harvey in 2013. She went to awards parties, Academy Award parties, dinners, etc. During the cross-examination, the prosecution moved to present other people's testimony. She maintained a friendly relationship with him. Then there was another complainant, C, established Hollywood actor, testified she met Harvey early 1990s, apartment, bedroom. Okay. 3 Molyneux witnesses. These are the ones that were really, you're not supposed to be able to put this evidence in here. You're not supposed to be able to put testimony like this in here. So just like in Diddy's case, there's complainants, which are being actually alleged, and, the stuff that they say and the stuff that was done to them is the reason, the basis upon which the government is charging. But then there was these other sideshow witnesses. They testified about his individual unwanted advances toward them. Witness 1 said she met him in 2004 at a night working as an actor, and Harvey said he could help her career. Sometime in 2004 or 5, she met him in a hotel room for a networking event, and activities allegedly occurred. Witness 2, again, not complainant. This is not being charged. It's just like random people they let come in. These things could be true. They could be true. I'm not saying they're not, but we don't know. And Harvey Weinstein is saying that these witnesses being let in on all of this stuff that we never actually had to go to trial for, we just literally just let them sit up here and say whatever they want. That's the real reason I got convicted, because people just thought I was a sexually depraved maniac because they took these women for their word, and I had to defend myself against it, which seemed profoundly unfair. And you know what? The appeals court agreed. The appeals court agreed. So I say all that to say, on April 10th, 2025, I predict that if these 3 witnesses are allowed to come in, these four allegedly so-called non-statutory victims are allowed to bring testimony in before the jury of prior sexual acts, Diddy has a very strong case to have it overturned, in particular because he has a whole extra argument as to he hasn't been even so much as charged in this case with an sexual crime. So does 413 even apply? Does that exception even apply? The circuit courts have not been able to agree. There's a split. It hasn't been decided at the highest of all levels, whether or not Diddy actually needs to be charged with SA or if some allegations of it just have to be cursorily mentioned. I think probably the first. I think probably Diddy is right. And again, y'all, this is because we have to follow those foundational constitutional principles upon which not only the republic is based, but upon which the entire system that we have is based upon. You have a right to a fair trial. You have a right to only be held accountable and held to account for the stuff you're actually charged with, or for the stuff that there's like undeniable evidence. I think there's some complicating factors which make Diddy's argument even stronger. Like all of these allegations are from decades ago. So who knows how much these people remember. I think one or more of them actually did sue him in civil court, but some of them never even did so much as that. And there are arguments like this to be made. I personally believe the government in Diddy's case either needs to actually formally charge him with an SA or let these witnesses go. Now, that isn't me saying that Cassie shouldn't be testifying and victim 2, 3, and 4 shouldn't be testifying, because those are the victims upon which their experiences form the basis for the charges. 2 separate buckets of so-called purported victims. There's the statutory victims, the ones that the government is charging him for Cassie. Like, that's pretty much what it seems like is going on to me. So Cassie, yes, it makes sense for her to give her testimony because he's going to get convicted on what he did to her, as well as victim 2, 3, 4, if he gets convicted, innocent until proven guilty. But these non-statutory victims, I don't know how often this is allowed. I don't know if this was just like a spinoff from the Harvey Weinstein case. I don't know if this all started in Me Too, or if this is just something that has been going on for a long time and it needs to be resolved. I did want to remind y'all this episode is sponsored by my merch. So here's the tank top, the little They Lied tank top for the summertime. And on the back, BJ Investigates. And of course, we can't get through a merch launch without a hoodie. And then also, look. She gonna find the truth. She gonna crack the case, yeah. Anyway, they're gonna be sold out. I think they're gonna be sold out this week. So y'all better get them because it's the last time I'm gonna make them. That's all I really had for this one. In the meantime, facts ain't defamation, and neither is reading a court document, girl. Love you, okay, bye.